Chair, I address you in respect of Ms. Mentor's evidence or completion of her evidence. The Chair will recall that according to the program, Ms. Mentor is scheduled to appear before you tomorrow, Friday, at which she is expected to conclude her evidence in chief and to be handed over for cross-examination. As things stand right now, Ms. Mentor is available and is willing to appear before you today or tomorrow. There are certain facts we would like to place before you, however, before you take a decision on the direction of her evidence, and they are as follows. After Ms. Mentor had testified, we as the Commission initiated certain investigations arising from her testimony. Since then, we have been receiving results of these investigations. In certain instances, some of these investigations, some of the results have prompted further investigations. We have about 3 critical investigations that are incomplete, that the results of which are very important, both for the Commission and the evidence of Ms. Mentor. We are of the firm view that it is only fair and appropriate that Ms. Mentor be given an opportunity to deal with the results of all investigations, whether the results contradict her evidence or whether they corroborate what she has stated. But she must be able to deal with them prior to being cross-examined and prior to being excused. We also think that it is in the best interest of the Commission to address issues in this fashion, because if we don't, the following is likely to happen. Ms. Mentor may come in tomorrow complete and then have to be recalled to deal with the results of the investigations, which results themselves may potentially prompt further applications for cross-examination based on the results, because the results of the investigations are shared with the implicated persons as well. We consider that to be slightly a tardy approach, and we would request for a better approach, subject to what the Chair says, which is to allow the investigations to run their course, to get all the results, or at least to get in most of the results, and then call Ms. Mentor to testify. At our current planning, we anticipate that at the most, the results should be in within 2 weeks, which results then to the extent necessary, which results will form part of the next bundle of Ms. Mentor, and to the extent necessary will be shared ahead of time with the implicated persons who've been granted right for cross-examination. For the Chair's information, we have communicated to those who have been granted right of cross-examination that we will be applying or requesting the Chair to consider deferring Ms. Mentor's evidence to a later date. We have invited them to be present today when we make this request, and up to this point, there's been no opposition to the state of affairs. So as far as their potential prejudice is concerned, we submit that we do not see any basis on which they may claim prejudice. With your leave then, Chair, we would request that Ms. Mentor's evidence be deferred to the next available date, which on the program is the 30th of November, at which she will complete her outstanding chief, and then she will be handed over for cross-examination. If the Chair will recall, there are 3 applicants to cross-examine him, all of whom have been granted the right to cross-examine, but on very limited issues, and we do not anticipate that anything new will arise that will interest the implicated persons from the investigations. What will arise is more to the benefit of the Commission and the Chair himself.
From what you say, it appears that the deferment that you are asking for is aimed at making sure that before that is Ms. Mentor, she resumes giving evidence, she has had an opportunity to consider the results of any investigations of various aspects relating to her evidence. And I guess also that that might also be fairness to to implicated persons in the sense that if that investigation results in certain issues that she has dealt with being seen maybe to support their version, it's all in the interest of everybody that we get to the bottom of the issues.
Indeed, Chair.
And I think it is important to ensure that issues that arise from her evidence be properly investigated, because if her evidence is ultimately found to be true by this commission, it could have very serious implications for implicated persons, or at least some of them, and if her evidence is not true, it could have there could be serious consequences also, because her evidence is really very pertinent to some of the issues we are investigating. So it's very important that the investigation of the issues arising from her evidence be properly looked into. So I'm inclined to grant the deferment. She has been consulted on the issue, understand?
Yes, Chair, I confirm she has been consulted.
Yes.
As the Chair is aware, Ms. Mento is not based in Johannesburg. She's in Johannesburg as we speak right now.
Yes,
and would have availed herself any moment from now if she were
Yes.
instructed to appear.
Yes.
So she is available and ready to appear.
Yes, so that's fine. The date of 30, that's also been canvassed with implicated persons, lawyers, or not really?
The date itself of the 30th, if I may just confer with the
Yeah.
attorney very quickly. Chair, thank you. Mr. Mabunda confirms that the proposed date of the 30th of November has been put to the implicated persons, yes. And it has also been canvassed with Ms. Mento, and it would, for now, suit her.
Yeah, okay, no, that's all right. In the interests of ensuring that there is a proper investigation of issues relating to the evidence presented by Ms. Mento before this commission so far, I conclude that her evidence, the hearing of her evidence, be deferred, and it will be deferred to 30 November 2018.
As the Chair pleases.
Thank you.
Thank you.
Thank you, Chair. The next matter for your consideration is an application for postponement by the legal representatives of Mr. Nene. Advocate Adila Hassem will address you.
Thank you.
Thank you, Chair. I appear together with my colleague, Ms. Raja, for former Minister of Finance, Mr. Nene. Chair, if I may begin with the summons. This is an application for postponement for a hearing that was due to take place today. The facts are set out in the application that is before you, in the affidavit of Mr. Nene, and it appears from the facts that the summons is dated 22 October 2018. However, it was at first sent to the wrong attorneys, not the attorneys, instructing attorneys of Minister Nene. It subsequently was then sent to the state attorney, the correct attorney for Minister Nene, but then suffered the fate of the dysfunctional email system in the state attorney's office. It eventually then made its way to National Treasury and the former Chief of Staff for Mr. Nene, communicated to him that the subpoena had arrived, but he only then, as he says in his affidavit, got news of it on the 8th of November. It was at that point we were then advised of his inability to appear as requested on the date in the summons, and he instructed us to bring this application on his behalf. The reasons for the postponement, is due to medical reasons, due to an injury that he sustained to his left ankle, and that is set out in paragraphs 9 and 10 of his affidavit. He has been required by his doctor to to limit his movement, as he states in his affidavit. We have attached a medical certificate, which is Annex E, page 16 of the application, from his attending physician, who says in that medical certificate that he is unable to resume duty until the 1st of January 2019. Chair, if I may, this morning, we received a more detailed letter from the doctor, and I beg leave to hand it up. You'll see that the letter is dated 15 November 2018. It's signed by the same doctor who signed the medical certificate at page 16 of the application.
Yes.
And perhaps the most important sentence is the last paragraph, where he states that it is recommended that he does not travel, that is Mr. Nene, does not fly or travel due to the risk of a DVT. He also needs to elevate and rest the leg in order for the fracture to heal. Mr. Nene also wished to stress to the Commission his willingness to cooperate, and that he will make himself available as soon as he is physically able to do so on any day after the 1st of January, and hopefully in agreement with the Commission's legal team.
Yes.
I therefore submit, Chair, that these reasons I set out in the affidavit constitute good cause, as we understand it from our common law and affirmed in the Constitutional Court in Shilobana. In any event, we submit that it's in the interests of the efficient and effective procuring of evidence from Mr. Nene that when he provides evidence, he's able to do so on the basis of being apprised of what evidence he will be required to provide to the Commission. I'm also advised that the matter is not opposed.
Yes. No, it's quite clear that he is injured and cannot travel or should not travel, and therefore he should be allowed to come at another time when he has recovered. He has been very cooperative to the Commission. He has been very helpful, so there is really no reason why the request cannot be accommodated. I take it that at this stage no date has been arranged yet, or is there?
No date has been arranged.
No date has been arranged.
But Mr. Nene has offered his availability from the 1st of January.
Any time from in January and beyond. Yeah.
Yes.
Okay, all right. I think what we will, I think Mr. Pretorius might want to say something. Thank you very much.
I'm indebted, Chair.
Thank you.
Thank you, Chair. As a formality, quite obviously the application is supported by the legal team. I might just add that although the application did not cite any other interested parties, the attorney for the Commission, Mr. Mabunda, has notified all those parties originally implicated and who were issued with notices in terms of Rule 3.3. We might just add that there are no persons who have sought advantages in terms of Rule 3.4, Nevertheless, everyone is aware and there's no opposition to the application.
Okay.
If I may just clarify two matters. Firstly, Mr. Nene had been issued with a summons to appear today, and perhaps as a formality, Chair, you should excuse him from compliance with the summons. But that is inherent in your order anyway.
Yes.
But the second point is there's an allegation in paragraphs... I'm sorry,
Should
Chair.
that summons have been issued?
Yes.
Should it have been issued? That summons?
That's a matter that the legal team decided to do in respect of all witnesses.
Yeah.
And it's a practice that has been applied thus far. It's always open to reconsideration and may be discussed with you outside of these proceedings. But as far as summons is concerned, there was a policy decision taken to avoid difficulties in programming as a friendly summons should be issued, and all witnesses should be treated the same way.
I will just set aside the summons. And so the summons that was issued in respect of Mr. Nene is set aside. The hearing of his evidence is not to proceed today. It's deferred to a date to be arranged between the Commission's legal team and his legal team.
Yes. May I just raise one other matter very briefly, Chair? In paragraph 5, or 6 rather, of the papers, and in her address to you, it was stated that originally summons was served on the wrong attorney. But may I just clarify? I've asked the attorney, Mr. Mabunda, to clarify that, and he instructs me that at some stage, Mr. Max Bakwana was in fact the attorney of record, and there was never a formal notification to us that that situation had changed, and that gave rise to the original service on Mr. Bakwana.
But had his current attorneys had communication with the legal team?
I'm not clear on that issue, but all I can say is that given historical facts, Mr. Mabunda was at the time under the impression that Mr. Bakwana remained the attorney for Mr. Nene. I'm not seeking to lay blame anywhere, merely to clarify from Mr. Mabunda.
Okay, no, that's all right. Thank you.
Thank you, Chair.
I don't know whether counsel for Mr. Nene looks like she wants to say something. Oh, no. Okay, all right. Okay. Thank you. We are done. I have made orders in regard to Mr. Nene's application. So we are done with that.
Thank you, Chair.
Yeah. Is that all for this morning?
We resume on Monday then with the evidence of Minister Gordon.
Okay, we are going to adjourn these proceedings until Monday, when Minister Gordon will then give evidence, and there are other witnesses who will give evidence next week. The proceedings are adjourned.